Please be seated. That was a longer walk across, so I apologize for that. Thank you very much for having us down to Jefferson College here. We appreciate it very much, and being in Jefferson County, without going into too many stories, I have fond memories of Jefferson College from playing tennis against them in college. You always had a good tennis team down here, so I always enjoyed coming down here. So at this time, I'm going to call the docket, and if the lawyers could announce the amount of time that they need. It's going to be 15 minutes for each side, and then 3 minutes for rebuttal for the appellant. There's no accelerated cases here. So if the lawyers would come, I guess, I don't know if we can hear you fully from down there. Why don't we try that? The first case is Richard Tao Investments versus Custom Insurance Incorporated. If the people would tell who they represent, their name, and how much time they need.
Gail Renshaw for the appellant,
12 and 2. Thank you.
Yes, Robin Fox for the respondents.
Say that again? 15. Thank you very much. The next case that's going to be on our docket will be Lyndon Knoll versus ABB Combustion. Okay.
Michael Scheller for the respondent employer, 15 minutes.
Thank you very much. We also have, at this time, we have also the case of Asset Acceptance versus Sharon Young. Will the lawyers approach and give us, come on up to the podium. Good morning.
Good morning, Your Honor. Good morning, Your Honors. Mitch Stoddard on behalf of the appellant, and I am prepared to announce that within the past 10 minutes, the parties have reached a settlement in this matter, and we will be dismissing. We've requested 14 days to finalize settlement, and we will be filing a notice of dismissal of the appeal.
Michael Payne on behalf of the respondent, Asset Acceptance. That is correct. The parties have reached a resolution, and the appeal will be dismissed within 14 days.
Do you mind giving just, without talking about any of the settlement, just giving a brief synopsis of what?
I would be happy to, because anytime I get an opportunity of talking about the consumer laws, my eyes light up.
Okay.
And this is a case brought under the, excuse me, the Fair Credit Reporting, the Fair Debt Collection Practices Act, which is a very powerful federal statute that protects debtors from unlawful, unscrupulous conduct of debt collectors. And in this instance, we had a petition that was filed, and there was an attachment to the petition that we're claiming sought money in excess of what was actually attempted to be collected. And our claim was that this additional amount, which was $15,000, and it was $4,000 different from what was actually stated in the petition, was a false figure. And the evidence that we intended to put on, or at least the argument that we intended to put on, is that the figure was false and would have misled or confused the least sophisticated consumer, which is the next standard that you have to show in order to show a violation. And in this case, the trial court found that, well, even though the figure may have been false, it did not or would not have misled the least sophisticated consumer. And I was going to argue why I disagreed with that finding of the trial court. And namely, there was evidence contained in the record that would lead a least sophisticated consumer to believe that $15,000 was actually trying to be collected, and it wasn't. So that was a false figure. The Fair Debt Collection Practices Act, in my mind, was violated, and this was a consumer in need of protection under that act.
Well, thank you. Do you wish to make any statements? You don't have to. You don't feel obligated to say anything if you don't want. I know Mr. Stoddard probably gave a...
He gave more than I would prefer. But in fact, the case procedurally, Asset Acceptance filed a motion for summary judgment, which is a motion that would indicate that based upon the evidence that had been presented to the trial court, without a trial at a summary judgment phase, that the evidence was insufficient to show that the least sophisticated consumer would have been misled in this case. And the trial court, Judge Miller, agreed that in essence, evidence had not been produced. There was no finding that the statement attached to the petition was false, but he did find that the least sophisticated consumer, because reading the pleading as a whole, would not have been confused. And so the case procedurally got to the Court of Appeals without a trial, but based upon a motion for summary judgment.
So I appreciate the time that you all spent. This it reinforces the theory that when you do a traveling docket, when you go places, you want more than one case, because the reality is cases settle at often right before and right after, and you just never know. And I appreciate your time, and thank you very much for coming down, and we'll see you on the next one.
Thank you, Your Honor.
Thank you. Appreciate it. What we'll do is we'll go to the first case that's on the docket, and if the councils would approach on Richard Tao Investments versus Custom Insurance. You may proceed when you wish. Thank you.
May it please the court, counsel.
Counsel.
I am Gail Renshaw, representing the plaintiff appellant Richard Tao Investments. The question in this case is whether a trial court can make judgments in a summary judgment proceeding on...
And what I'm going to do, if I can, I'm going to give you a little heads up. I'm going to give you like an extra 2 minutes if you want to go into more detail factually for the audience instead of taking it from your time. You're welcome to do that, because in the past what's happened is sometimes people have spent too much time trying to get into the facts to give some of the audience the background. I know some of them have position papers, but just we'll give you a couple extra minutes if you need,
Okay.
and go in as much detail as you think is appropriate.
I appreciate that. The facts of this case are plaintiff Richard Tao Investments invested $200,000 with Camera Construction Company. Camera is a small construction company, a one-man operation, and he began to get involved in building houses. And my client heard about him, the Richard Tao Investments, and decided to invest $200,000 in a specific lot to build this house, and then the house would be sold, and the plan was that my client would, get his investment back. Well, what happened was the Camera started building, and about when the house was 3/4 finished, there was a fire, totally destroyed. So the question and the issues in this case involve insurance coverage. And what my client brought an action as an assignee of Camera who went bankrupt for negligent procurement of insurance and negligent misrepresentation. Now, the procedural history of the case is the complaint was filed, the petition was filed, and then an answer was filed, and defendants who were the insurance agent and the broker agency filed a motion for summary judgment, which was granted by the trial court. And the question in the case is whether the trial court in this summary judgment proceeding can make a judgment as to the weight of the evidence. And our position is that that's exactly what he did. And had he not done that, he could not have granted summary judgment. I know that the court's familiar with the standard of summary judgment as well as the standard of review, which is de novo, so I'm not going to re-quote all those phrases that say what it is. However, it needs to be examined in the context of this case. Under the negligent procurement theory, the elements of that are, number one, that the defendant's insurers agreed to procure insurance, which is not in dispute. The second element is that the insurance agent did not procure the insurance agreed on and was negligent in doing so. And this is really where the big dispute in the evidence is. What happened is Kammerer Construction had their original policy with Americom Family Insurance. They're not involved in this at all. But he wanted to get a better deal, better premium price. So he contacted the defendant agency, and Ron Schneider, the defendant agent, was the one who came out and discussed insurance with him. Now, there's a dispute as to what transpired in their conversations. Kammerer said he told him what he did, that he was building these houses. Schneider said no, he didn't say that. He just said he was like a construction company. Okay. And so Kammerer also said he wanted everything covered, basically. He's not an expert in insurance. He said, take care of me so that everything's covered. All right, now the documents in this case were extremely confusing. There were multiple policies produced, but what happened is Acuity Insurance is the policy in question, first of all. What happened, and I think that, well, I know that's not in dispute, is that the original policy that was issued did not cover construction going on lots. Now, there were 2 lots involved in Mr. Kammerer's business going on at this time. One was Lot 1, which is what the plaintiff had invested in. There was another lot called Lot 19 that my client had nothing to do with, but Kammerer wanted everything covered. Okay, and the original policy didn't cover these construction projects. Now, defendant's position is that the policy was amended and that the amended policy covered the lot. They're showing a policy that says, yeah, it's covered, and defendant Schneider, though, testified that the Acuity policy never covered fire loss on these lots. Now, additionally, this was in an original affidavit and in his deposition. He later files an affidavit where basically he's saying he's confused about a lot of things, and that, and sort of, it does conflict with his previous testimony. And plaintiff had filed an originally, after this was submitted with their motion for summary judgment, plaintiff filed a motion to strike that. Now, the judge had taken the summary judgment motion under consideration, and it was anticipated by me that he would rule on that motion as well. Well, he granted the summary judgment and really didn't rule at all on that motion, so it was, by not ruling on it, it was overruled. Anyway, what happened, back to the facts, is, okay, in addition to the Acuity policy, a policy that was obtained through Zurich was also purchased by my client. Now, again, this is where there's a lot of dispute in the facts. Schneider said this policy would have covered Lot 1 and would have covered fire loss. But as it turned out, after the fire, after Schneider comes out and says, yeah, you're covered, it turns out the Zurich policy was on Lot 19, not Lot 1. Now, the reason for obtaining that separate policy, Kammerer, who was the owner of who purchased the policy, said that on Lot 19, there was a mortgagee, a bank, that requested a separate policy. No reason given other than because they were on a mortgagee and they wanted to be on the policy. Nothing in Schneider's first affidavit or deposition said why the policy was covered other than the mortgagee required it, but his later affidavit says, oh yeah, the policy was required because earthquake was not covered under the original policy. Okay, well, this is a dispute in the facts. And
Ms. Renshaw, was one of the undisputed facts that the acuity policy had lapsed for failure to pay? Was that undisputed?
well, no, it's not undisputed because although it's undisputed that he had, was late in payment, the question of cancellation is disputed. Kimmerer says he never received a notice of cancellation. Defendants say yes, acuity sent a notice of cancellation. Schneider thought he was covered after the loss, came out and, said, yeah, do this, and he, in fact, had him sign something about there was no loss, and he was talking about another policy, and as it turned out, it was only later that they determined that, no, he was not covered.
Now, the reason that's important is because in a negligent procurement of insurance, that's one of the elements. You have to have an agent who agrees to procure the insurance and then negligently does not, and then damages are caused as a result.
Correct.
So if it was undisputed that payment had not been made and the policy had been canceled, then the court would be correct in granting summary judgment. But you're saying that it was disputed.
Yes, yes. The fact that payment was late, that's not disputed, but the fact that, the issue of cancellation, whether it was effectively canceled, is in dispute.
But acuity is not a party here, correct?
No, I don't think it has to be a party, because what the evidence is relating to is causation of damages, not who is responsible, for that. So that's the point of that, but they don't need to be a party. And moreover, you can have more than one proximate cause. There was some additional evidence back to the negligent procurement part, and one thing is a letter, and I did mistakenly say in my brief, for some reason I believe that at the time that it was from the defendant's attorneys, but in fact it was from Acuity's attorney. I apologize for that error, but I was certainly not, I don't think that has an effect on my point of showing that. The letter was from the attorney of Acuity stating that defendant Schneider had committed numerous negligent acts. Well, if you take the standard of giving the benefit of the record to the non-movement and any inferences, this is some evidence of showing negligence. As for the second element of the causation, as I said before, it was in dispute as to whether cancellation was effective. Finally, defendant raised in their brief the issue that plaintiff's claims were completely barred by the doctrine of contributory negligence. This is a non-issue. The trial court found it to be a non-issue, and it's clear that Children's Wish Foundation overruled that theory, and although defendant argues that should not be applied to this case, if you look at the Children's Wish Foundation, it was applied to the parties in that case, in their own case. So, and Gustafson, which is also about personal injury and comparative versus complete bar, that specifically applied to all cases whose trials were coming after it, not totally prospective. So, as to claims. So, under those cases, this certainly does not bar the claim.
2 minutes.
So what we have conflicting facts. And the question is, can the judge weigh the evidence? And in this case, the judge did weigh the evidence and found defendant's evidence more convincing. We may lose at a trial, but we are entitled to a trial and having the trier of fact decide the case, not the judge in a summary proceeding. Therefore, we're asking the court to reverse the trial court and remand the case for trial so that the trier of fact can determine these issues. Thank you so much.
Thank you.
Good morning.
Good morning.
May it please the court, counsel. I'm here on behalf of the respondents, Ron Schneider and Custom Insurance Services. It is our contention that Judge Stoll properly entered summary judgment in this case. He found that a policy was obtained that covered the loss that's at issue in this case, and the only reason that there was no coverage was the policy was allowed to cancel due to non-payment of premium approximately 2 weeks before the fire. As counsel indicated, there are two
And they got notice 2 weeks before the fire about that, correct?
two notices, according to Acuity's affidavit and the documents that were produced and are part of the record. Two notices were sent out about 2 weeks apart, notifying them of the cancellation. But I don't think, they made some issues here about whether or not the cancellation was effective or not, whether or not it was done properly. I don't think that that has a bearing on the claims against my client. My client had the duty to procure the policy, which is undisputed that the Acuity policy was put in place. The court found as a matter of law under the terms of the policy that was procured, there was coverage for the fire loss. So if there's any dispute of whether or not the cancellation was effective, I think that claim really goes to Acuity, because Acuity has indicated the reason they denied the claim was the policy was not in effect at the time of the fire, and that was their sole basis for denying the claim. There are two separate claims that were before the trial court. One was the negligent failure to procure. The court found that that claim could not survive because a policy was in fact procured that covered the loss. There's been a lot of talk about that there's a dispute as to what was, a factual dispute as to what was covered by the policy. But the policy that was issued has to be construed by the terms of the contract. It is a question of law. The courts have repeatedly said that that's why it's appropriate, especially in coverage cases, for summary judgments to be granted, because it is a pure question of law as far as what the terms of the contract are. This policy had a course of property in the course of construction coverage, which covered any job site where Mr. Kramer was doing construction work, and it covered the buildings. It also covered fire loss. So that was in place, and it had $1 million limits. So that was in place, and it fulfilled the requirements of Kramer, and it also would have covered the loss that's at issue. So plaintiffs cannot make their claim for failure to procure because, in fact, a policy was procured that covered the loss. In terms, there's a second claim for negligent misrepresentation. It's about some statements that were allegedly made after the fire occurred in terms of what was covered and what policy provided the coverage. The court determined that those issues were not material to the case because the claim was denied because the policy was not in place. It was canceled due to lack of payment of premium. So regardless of what was said, it doesn't matter. There was no coverage for the case, so there could be no causal relation between the damages that were incurred by the plaintiff, or I guess Kramer Construction, and then assigned to the plaintiff, because the cause of no coverage was not related to any of those statements that were made. They were all after the fact and had no bearing on the cancellation. We did raise in our brief and in our motion for summary judgment as an alternative ground that the claim should be barred based on the contributory fault of the parties. While about 4 years after this claim accrued, there was a change in the law by the Supreme Court in the Children's Wish case. It's our contention that would be unfair to apply it to this case that was already, the discovery was already completed, the parties had already started their strategy, and the claim had been 4 years before. But I really don't think the court has to reach that issue, because I believe that Judge Stoll was correct, that a policy was in fact issued and it covered the claims, and the only reason that it did not provide coverage was because it was canceled because the Kramer Construction failed to pay the premiums. So we believe that the summary judgment should be upheld.
So if they paid the premiums, it would have covered it?
Yes.
No question about that.
No. I know it's determined by the policy, and the judge interpreted the policy, and I think it's clear. It covers every job site, any building and construction, and fire is not excluded, so it would have covered.
Thank you very much.
Okay, thank you.
Rebuttal.
With respect to the policy, the plaintiff appellant is not arguing to interpret the policy that they submitted. The argument and our position in this whole thing is that the dispute is over what policy was in effect. And that's where the facts are very muddy and in dispute. So it's not a question of interpreting one particular policy, because yes, interpreting the language of a policy would be a question of law. This involves whether that policy was in effect. Thank you.
Thank you very much. We're going to do a question and answer session after the next argument is done. So I'm not saying you have to stay around, but if you're around, people may have questions. If you can't, I understand. I know you guys are busy. I'm going to call the next case up at this time. This is Linda Knoll versus ABB Construction Engineering and Second Injury Fund. Will the lawyers approach? And as I indicated to the lawyers in the other case, we'll give you a couple extra minutes if you can give sort of a good background and factual to get the audience up to speed on it, would be greatly appreciated too. You may proceed when you're prepared. Thank you.
May it please the court.
Counsel.
Mr. Schaller, good morning. Your Honors, this case involves the appellant's need for pain management and for psychiatric medication. As part of her treatment, it resulted from a work injury she had in 1997 that caused significant low back injuries as well as psychiatric injuries. It also involves the respondent's recent change in those medications based upon the opinions and recommendations of Dr. Michael Jarvis, a psychiatrist who has never actually treated Ms. Noel and only evaluated her on one occasion. More importantly, it involves the issue of whether the changes in those medications will endanger her life, health, or recovery. And that's what our position is. From a factual standpoint, Ms. Noel had a number of injuries while she was working with ABB. The case at issue at this time is an injury involving her low back that also caused significant depression and anxiety in 1997. That injury required multiple low back surgeries, resulting in failed fusions and failed low back syndrome, continuing need for psychiatric medication for anxiety and for depression. The case was tried before Chief Administrative Law Judge Jack Nolan. Judge Nolan entered his final award in favor of the employee, the appellant in this case, and awarded her, among other things, future medical care and treatment to cure and relieve her from the effects of her low back injury, the physical injury, and also her psychiatric injury. The respondent appealed that to the Missouri Labor Commission. The Missouri Labor Commission affirmed Judge Nolan's award, but modified it slightly on an issue that's not at issue in this appeal. No further appeals were taken. For the next several years, Dr. Stephen Granberg, Dr. Gordon Robinson provided Ms. Noel with pain management and psychiatric treatment, including medication. Last year, the appellant was advised by a respondent that a number of those medications were going to be changed or stopped altogether. At that time, on behalf of the appellant, a motion was filed with the Labor Commission asking them for an order preventing that change to be made, or in the alternative, to reopen the case to consider the issue, excuse me, of those changes in her medication. As the court knows, this case is on appeal from that order, the Commission's most recent order in 2012. That order denied our motion to prevent the respondent from making those medication changes.
Do we have the authority, I guess, it says, if it be shown to the commission that the requirements are being furnished by the employer in such a manner that there is reasonable ground for believing that life, health, or recovery of the employer is endangered thereby, the commission may order a change in the physician or other requirements. Do we have to wait and see if the changes made by the employer here actually endangers Ms. Knoll's health, or do we have the authority to prevent the change before that occurs?
Your Honor, the changes have been made, and our position is that the Labor Commission certainly has the authority to do it. That's what we asked them to do. Our position also is that the Court of Appeals has the authority to reverse the Labor Commission's finding in its order, to remand it to the Labor Commission with directions to enter an order in accordance with the Court of Appeals' opinion. With respect to your question specifically, Dr. Robinson has been a treating psychiatrist for over 11 years, and that's been at the direction of the employer respondent. Dr. Stephen Granberg has been the appellant's treating pain management physician, board certified, for over 10 years. Again, that was at the direction, and still continues to be at the direction, of the employer respondent. Dr. Granberg, in his deposition, testified that the appellant's work-related accident and injury and resulting failed back syndrome is the substantial factor in causing her need for the pain management and for the medications he prescribes her. With respect to the issue of Section 287, 140.2, which you just recited, Dr. Granberg specifically said, quote, "The changes in her pain management medication, as proposed by Dr. Jarvis, would put the appellant at risk for having withdrawal symptoms, possible overmedication, and the inherent risks associated with methadone, including cardiac abnormalities." Dr. Granberg further testified there is no medical reason to make any changes to the appellant's medications whatsoever except for cost purposes. Now, with respect to your question and the pain management, Dr. Granberg has been treating the appellant for over 10 years. His opinion is that these changes will be detrimental to her health. I suppose my question is, do we have to wait until that detriment happens, or can we base the finding upon the treating pain management physician's opinion that yes, these changes will be detrimental to her health? And similarly, with regard to Dr. Robinson. Again, Dr. Robinson has been treating Ms. Noel for over 11 years for the psychiatric conditions that she suffered as a result of her injury. Dr. Robinson testified that the depression and anxiety for which he's treating her flow from the 1997 work accident. Specifically with respect to 287.140.2, Dr. Robinson testified that taking the appellant off of the 5 psychiatric medications as recommended by Dr. Jarvis would most likely result in a relapse of her depression and anxiety, and that following the recommendations of Dr. Jarvis, again a psychiatrist who never treated her, saw her on only one occasion, would put the appellant's health at significant risk. Not may, but would put the appellant's health at significant risk. I think that that decision can be made by this court, and I think it should have been made by the Labor Commission.
Go ahead.
I was going to say, normally we can't go behind the findings of credibility of the commission. We have to stay with that. And in this case, they found Jarvis more credible than the other experts. How do you address that?
The crux of the commission's finding was that the appellant failed to carry her burden of proof that the medications being prescribed were reasonable and necessary to cure and relieve her from the effects of the injury. I think that's different than saying that the credibility of Dr. Jarvis is held at a higher level than the credibility of the treating physicians that have been monitoring her pain management and psychiatric medications for 10 and 11 years respectively.
Do we have to remand back for credibility determination?
To my recollection, Your Honor, I don't believe that the Commission made that determination in its order. I don't think that they mentioned credibility. Again, I don't think the credibility issue here it's important to an extent, of course, but I don't think it's nearly as important to the case as to the obvious and serious effects that these treating physicians feel Ms. Noel, the appellant in this case, is going to suffer as a direct result of these changes in medications. And it's been prevalent throughout the history of this case for almost 16 years now with respect to cost issues. If the court looks at Chief Judge Nolan's final award, the first award that was issued in this case, he notices this. It raises his eyebrows, and he says, quote, "The employee seems to be responding very well to the physician selected by the employer." This was written in 2007. Those physicians that he was referring to are Dr. Granberg and Robinson. He went on to say that any attempt by the employer insurer to change physicians would appear to be motivated solely by an effort to reduce the cost of the medications being prescribed by them, rather than any concerns about the physical or mental condition of the employee. There's no basis for these changes in medications. Clearly based upon the opinion of the treating doctors, again at the respondent's direction, the pain management physician and the psychiatrist, these changes will be detrimental to Ms. Noel's health. I don't think we need for her to have a relapse of her depression or of any other physical or mental symptom that she's been experiencing now for 13 years before that change is made. The doctors that have been treating her for this long extended period of time testified that within a reasonable degree of medical certainty, these changes would be detrimental to her life, health, or recovery.
You got the administrative law judge in 06 determining that that the depression is work-related.
Yes.
And then you have Jarvis here saying he doesn't believe the medications, all the medications she's taking are effective for her depression because he believes her depression comes from a pre-existing personality disorder. In a sense, it's not related to the injury. How does the court deal with that? How can we go behind that and upend what's occurred? I'm throwing a softball out to you, I guess, but.
Yes, and thank you for raising the issue because it's one that I definitely wanted to address. With respect to pre-existing conditions, I believe that's what you're referring to. There's a lot of discussion in the respondent's brief about the existence or presumed existence of pre-existing conditions. I think Bowers versus Highland Dairy clearly answers and addresses that issue. Bowers held that in determining whether medical treatment is reasonably required to cure and relieve a compensable injury, it's immaterial that the treatment may have been required because of the complication of pre-existing conditions, or that the treatment will benefit both the compensable injury and the non-compensable or pre-existing condition. Rather, once it's determined that there has been a compensable accident, as in this case, a claimant need only prove that the need for treatment and medication flow from the work injury. In this case, the appellant has met that burden of proof. The court in Bowers went on to hold that the fact that the medication or treatment may also benefit a non-compensable or earlier condition is irrelevant. In this case, there is some factual evidence that Ms. Noel may have taken antidepressant medication before her work injury in 1997. There's also factual evidence that she didn't have the greatest childhood or early adulthood, and that there were definitely some family stressors. Dr. Robinson, the treating psychiatrist for 11 years, testified that within a reasonable degree of medical certainty, the medications he's prescribing to her are being prescribed based upon the injury that she suffered at work, and that's based upon, and that's the substantial factor requirement that has been met because it's a pre-2005 case. Even though there may have been some pre-existing indications of depression, some pre-existing indications of conditions from a psychiatric standpoint, Bowers clearly says it's irrelevant. As long as the medications that we're currently discussing, and the ones I'm discussing specifically are the ones being prescribed by Drs. Granberg and Robinson, as long as those are reasonable and necessary to treat the condition from which she suffers as it's related to the work injury, any pre-existing condition that it might also benefit is completely irrelevant.
With regard to Dr. Jarvis, he discusses a lot of the medications, but he doesn't, he recommends that they all be stopped except Zoloft. But he does not specifically discuss Ambien, Synthyroid, and Valium. He simply concluded that she should only stay on Zoloft. Does that mean that Robinson's opinion that she needed those medications were not refuted, the specific three? That's not mentioned by Jarvis.
Is your question that Dr. Robinson doesn't dispute the fact that...
No, well, that his opinion is not refuted by Jarvis because Jarvis doesn't address those three medications. He just says, he addresses, I guess, 7, says she should stay on one or switches one, and doesn't address the 3 others.
Yes, I think that that's definitely a fair way to read that, and that's been a confusing point, that again, the Commission didn't address that in its order either. With all due respect to the Commission, there are a lot of holes in the Commission's decision, a lot of answers that were not provided to counsel, myself or Mr. Schaller, with respect to where do we go from here. The remand hearing was held, it was conducted, additional evidence was put on. We both valiantly argued our positions in our briefs to the Commission. The Commission denied the motion to prevent the medication changes, but didn't give any substantive guidance other than saying that we met or we failed to meet our burden of showing that all of the medications are not reasonably required. We feel that that burden has been met time and time again, and on appeal this particular time we feel that it's been met. We're asking the Court of Appeals to reverse the Commission's decision in its order and either to enter its finding that the medications that have been stopped at the recommendation or changed at the recommendation of Dr. Jarvis be prevented from being stopped or changed. May I finish?
Yes.
Thank you. And if the court doesn't feel that it has jurisdiction to do that, then we're asking the court to enter its opinion, remand the case to the Labor Commission with directions finding that the appellant has met her burden of proof regarding her need for the medications, that they arose out of and in the course of her work-related injury, and that to make changes would be detrimental to her life, health, and recovery.
Thank you, guys.
Thank you.
Good morning. May it please the court, Mr.
Counsel.
Link. My name is Michael Schaller. I'm here representing the employer respondent in the case. To respond to one of the court's questions, the Labor and Industrial Relations Commission certainly does not need to wait until any proposed change in medication causes harm to the appellant before they have jurisdiction to come in and ask. They can attend to, they can rule upon Mr. Link's motion, provided that the condition precedent is met. And that condition precedent is that the appellant has to show that her need for psychiatric and pain medications arose from the work-related injury. The Commission determined that the appellant did not discharge that burden of proof. For this court, the sole issue is whether or not there is competent and substantial evidence on the record as a whole to support the Commission's decision. That is the Commission's decision against the overwhelming weight of the evidence. In this case, the appellant sustained 3 work-related injuries, 97, 98, and 2000. Judge Nolan did determine that the employer was responsible for continuing medical care and treatment, including psychiatric care and treatment and pain management care and treatment back in the 90s. That was his decision. Dr. Robinson has been providing psychiatric care and treatment with a cocktail of various psychiatric medications since 2001. Dr. Granberg has been doing so since 1999. The issue is, have any of those medications cured and relieved the effects of the claimant's injuries? Do her current conditions that require those psychiatric and pain management medications arise and flow from the work-related injuries? The evidence in the record is clearly that they do not.
So, counsel, the administrative law judge in 06 made the determination that the depression was related to the work-related injury. That was a determination also made in 97, correct? 97, 2006. And so every time this is brought up, it's the responsibility of the employee that she has to make that causal relationship, that it's still, her depression is related to the injury from 97, 98, and 2000, correct?
Well, the appellant does not take the position that the appellant does not have that burden of proof. And clearly the appellant does have the burden of proof. It's the obligation of the employer to provide medical care and treatment that is reasonably required to cure and relieve the effects of the injury. This is an unusual case. Normally in a continuing medical care and treatment case, there will not be an issue whether or not the medical care and treatment is related to the injury. Take a prosthetic case. A prosthetic will wear out over time. The issue is not whether or not a replacement prosthetic is needed to cure and relieve. The issue will be, does the employee require a Chevrolet or a Mercedes prosthetic care and treatment? This is pain management, this is psychiatric care and treatment, and the record is replete with the fact that this lady has a variety of causes for her depression, which leads to the need for psychiatric care and treatment. The record demonstrates that during the course of her childhood, she was a victim of emotional abuse, sexual abuse, verbal abuse. She has 2 failed marriages. She has problems with her kids who are drug abusers. She was a victim of sexual harassment on the job. She feels a hostage in her household because if she does not support her ne'er-do-well son, she will not see her unborn grandchild. She complains to her psychiatrist about migraines, about her terminally ill brother, about her mother who went into assisted care and who has Alzheimer's, and the problems that she has with her mother. The lady, quite frankly, has a lot of issues and problems. And for this case, the commission determined that the appellant failed to establish that her current need, her continuing need for psychiatric medications, flowed from the work injury. Dr. Robinson, the treating psychiatrist, said it's a multifactorial situation here. She has genetic predispositions toward depression. She has close relatives with depression. She has low thyroid function because she had to have her thyroid gland removed. She has financial problems. Dr. Robinson has been prescribing such things as vitamin D because we live as a society more indoors than outside. I don't know what vitamin D has to do with psychiatric injuries flowing from the work-related injuries. Dr. Granberg has changed things over time. He's prescribed medications for non-label uses. He's prescribed medications that are 2 and 3 times the recommended dosages. The problem is here we have Dr. Robinson saying multifactorial. We have Dr. Jarvis saying this lady has personality issues. She has extensive social stressors. Should the employer be responsible for providing continuing psychiatric care and treatment when, over the course of more than a decade, the lady doesn't talk to Dr. Robinson about I'm depressed because I had pain in my back from my work injuries. She talks about everything else under the sun that I've already related to you. Does her need for psychiatric care and treatment flow from all of these other problems in her life history? Or does it flow from her work injuries?
How can you separate all that out? I'm not sure.
Well, I suppose if the lady would be going to Dr. Robinson over the course of the last 2, 3, 4, 5 years and saying, I'm depressed, I feel down, I feel blue, I can't function because my back is killing me, and my back's been killing me for the last 15 years, then I suppose that perhaps the psychiatric medications are needed to treat her depression and her psychiatric issues related from her work injury. But that's not what she's doing here. She's being treated for everything else but depression related from her psychiatric
But
injuries.
Zoloft is something to be treating her for depression still, correct?
It is.
So by Jarvis giving her Zoloft is sort of an acknowledgement that there is depression related to the work.
Well, no, it's an acknowledgement that there's depression. There's depression related to her extensive social stressors. This lady, according to the record, was on Zoloft before her first work-related injury. With respect to her pain management, this lady, the record indicates, was on extensive narcotic medications 4 years prior.
So realistically, if you're arguing that it's not work-related, that it wasn't proven, then you should be able to prevent her from taking any depression drugs because it's not causally related to her work injury in 97, 98, or 2000.
Well, I think that's what the commission said in its determinations, that the appellant had not met her burden of proof of showing the requisite nexus to the work-related injuries. She may well need her medications, the commission said, but the appellant has not met her burden of proof of
So
establishing
if she
the
hasn't
causal
met her burden of
nexus.
proof, then she shouldn't, then the employer technically is not responsible for anything.
Technically not. That's correct.
But the employer now is saying, well, we'll keep giving her Zoloft and keep paying for that.
Well, the employer, contrary to Mr. Link's assertion here that all we're concerned about is dollars and cents, that's not the case. You know, our recommendation, we intend to follow Dr. Jarvis. We intend to, follow a course of action that will wean her off of various medications, both psychiatric and pain management, put her on methadone, wean her toward methadone, see how the Zoloft works. Dr. Jarvis believes that you need to treat the extensive social stressors in this case. Now, with respect to the pain management for the back, the problem here is that Dr. Robinson, the treating psychiatrist, even doesn't believe that those pain medications are necessary to cure and relieve from the effects of the injury. Dr. Robinson saw Ms. Noel 268 times in the decade that he treated her up until December of last year. On at least 20 occasions, he wanted to put her into a detoxification program to get her off of the narcotic medications. Why? Because he didn't think they were a good thing for her. He didn't think they were helping her. When Ms. Noel saw Dr. Jarvis in 2010, she was still complaining of pain in her back at a level of 9 out of 10. These narcotic medications over 9 years, 10 years aren't working. Dr. Granberg, when his deposition...
Let me go back. So if she's been taken off all these medications and she's on Zoloft, and what else is she on right now?
Well, she's still on a variety of pain medications.
And the pain medication. If you try to get her on the methadone with regard to the pain, if that is not working, do you believe the employer has a responsibility to increase or change the medications to something else?
Dr. Jarvis has said that this is going to be very difficult for Ms. Noel because over the course of a decade on all of these various medications, she's become dependent. She's going to be resistant, just like she was resistant to Dr. Robinson, who wanted to detoxify her. you know, are we going to have an obligation to try various other things? I think we're going to have to defer to what Dr. Jarvis says.
But Jarvis has only seen her once for an IME, correct?
Jarvis has seen her once, but we're going to have to respond, I suppose, to what happens in the ensuing months as we go down this road. But again, I don't know how far exactly our obligation is, because the commission has determined that the claimant has not met her burden of proof, and we believe that there's competent and substantial evidence in this record that the decision of the commission is not against the overwhelming weight of the evidence.
Did the commission find that the pain she was experiencing did not flow from the work injury?
The commission simply held, Judge, that the appellant failed to satisfy her burden of proving that her prescription medications are reasonably required to cure and relieve from the effects of the injury. That's what the commission held, which we believe is a condition precedent. You have to have that requisite determination before you can address Mr. Link's motions and determine whether or not proposed changes are going to be a detriment to her. And again, that's a decision in the first instance for the commission to make, not for this court. The commission has to first make the decision whether or not the need for the medications flows from the work injury, and then secondarily address the motion whether or not any proposed changes will negatively impact Ms. Noel. Now, with respect to Dr. Granberg, the problem with Dr. Granberg is...
Can I?
Certainly.
In '06, the administrative law judge makes a determination that the depression flows from related to the work injury. The other administrative law judge previous to it. So in 2012, Jarvis says the depression is not related to the work-related injury, correct?
Correct, and Robinson also states that this is multifactorial.
Okay, you may proceed.
He also states it's multifactorial, a variety of reasons. The problem with Dr. Granberg and his assessment in this case is Dr. Granberg testifies that he has 5,000 patients. He also testified that he has delegated the care and treatment of Ms. Noel to a physician's assistant who simply has her come in, writes her another script, as he must do every 30 days, in order for her to get the additional medications. Dr. Granberg testified he does not know what her current complaints and problems are. He's not in a position to determine whether or not the need for medications is related to the work injury. And certainly, if she's still at a pain level of 9, fluctuating between 6 and 9, all of these high doses of narcotic medications, highly addictive narcotic medications, are neither curing nor relieving her of the effects of her injury. Dr. Robinson...
But if she's not taking it, could her pain be at 10 then?
I don't know how one subjectively, I mean, your pain of 9 and my pain of 10, I don't know how we do that. Could her pain increase without it? Certainly, it's a possibility. But at the same time, maybe she's become so dependent on these medications, these cocktails of narcotic medications, all of the various psychiatric medications over the year, that they're really not having an effect, that maybe this is all subjective for her. I also note in the record...
And I'm not going to deny that, but the thing is, you know, sort of going cold turkey, I guess that's one approach to attempting to deal with the situation in a sense.
Well, no one's advocating cold turkey.
Well, going from 11 down to 1, but...
Well, but again, the issue is, have the psychiatric medications provided, have they cured and relieved the effects of the injury? I don't think so. Dr. Robinson says they're not intended to do so. Dr. Robinson says, I hope she's on these psychiatric medications for the rest of her life. Dr. Jarvis says, let's put her on Zoloft, let's treat her reaction to all of these social stressors, let's see where we are. That's what he's saying. Do we continue to do what we've done for the past 10 years, 12 years without result? Is that what the obligation of the Workers' Compensation Act is? The commission seems to say no. You, the injured employee, have to demonstrate now 5, 6 years after Judge Nolan, that your need for medications and treatment still flows from the work injury.
Was there a credibility determination made by the commission?
I don't know if the commission made that credibility determination. I've read to you exactly what the commission said in its award, but I think implicitly the commission is looking at the evidence from Jarvis, Robinson, Granberg, and the rest of the records submitted to the commission, and determined that the evidence, when all the evidence is considered, is, appellant, you haven't met your burden of proof. And if they have to make a credibility determination when looking at Jarvis and Robinson and Granberg, the various deficiencies and fallacies that I've talked about, then perhaps they did. But specifically, did the commission say, we find Jarvis to be credible, we find Granberg not to be credible? They did not do that.
Thank you so much.
Thank you.
Appreciate it.
There's a number of things that I certainly disagree with that Mr. Schaller had raised. Unfortunately, time doesn't allow me to address them all. With regard to the issue of medical causation, that issue was resolved in 2006. It was affirmed by the Labor Commission in 2007. It's not an issue now, and it is not the appellant's obligation or burden to reprove that issue, to relitigate that issue every single time a medication change is made or proposed by the respondent.
How about in 20 years? Would you still don't believe in 20 years you have to prove it?
Your Honor, I do not believe in 20 years that she has to prove that. The condition...
If somebody comes in and says that condition is over, you have to prove it then.
If somebody comes in and says that you no longer suffer from depression, then I don't think that she's required to expect medication to treat depression. As long as the diagnosis of depression continues, her burden of proving that that diagnosis is related to her work injury in 1997 was met in 2006 and affirmed by the Labor Commission in 2007. It's not her duty to prove that every time this issue is raised by the respondent. It's unfair to require her to prove that every time that the issue is raised. With regard to Mr. Schaller's comment about Dr. Robinson wanting to place Ms. Noel into detoxification on 20 different occasions, that's a little inaccurate, I believe. Dr. Robinson testified that he discussed that issue with Ms. Noel on several occasions. Ultimately, he testified that decision should be and would best be left to the decision and opinion of the treating pain management doctor, Dr. Stephen Granberg. Dr. Granberg's of the opinion that she does not need detoxification, that the medications he's prescribing for her and has been over the past several years, that they're being provided in an efficacious way that, to this point, have benefited her in a way that no other combination of medications have with regard to the relief of her pain. Now, with regard to cure and relieve, the respondent spends a good amount of time on that issue in its brief as well. The argument, I believe, is misplaced, and Brolier versus Van Alstyne, I think, points that out. That case holds that when the Workers' Compensation Act is considered as a whole, the term cure and relieve must also be considered cure or relieve. Otherwise, it would completely disembowel the intent of the Workers' Comp Act. If you take, for example, an injured worker that suffers a traumatic brain injury, has cognitive dysfunctions, has loss of memory issues, has loss of balance issues, and a number of other problems that you can't see, feel, or touch that go along with a traumatic brain injury. You can't cure those conditions with medication. You can't cure those conditions with a scalpel. All you can try to do is to relieve the symptoms as best they can be relieved. And that's what we're trying to do in Ms. Noel's case.
Thank you very much.
Thank you, Your Honor.
Appreciate it. What we're going to do at this time is we will open the floor up for any questions here. What I'd like to do is give a little parameters for the questions. We can't comment upon the pending case necessarily about what the result's going to be or get too far afield into questioning about the case, but if anybody has any questions about what's transpired here of the judges or any of the lawyers, I see the other lawyers here, we're happy to answer them, and I'd like to say I can see if anybody raises their hand, but the light's shining, so if anybody has a question or, wants to talk about the procedure, they're welcome to do it at this time. I'm not seeing many hands raised unless I'm missing. Is everybody awake? We had some cases are much more interesting, like some of the criminal cases really get really hits home on a lot of people. But the first case was a very is a narrow case. It's insurance, and sometimes it doesn't. It's an important, very important, but it just is not as it doesn't bring as many questions out. And I think the last case was a very interesting case in many ways. So we'll have to. What we do after this is we go back and we discuss the case, and we do pretty much tentative decisions how we decide how we want to go to make a ruling on the case. And what we do after that is there's one of the three of us will be writing the case. We don't indicate who it is at this time, and that opinion is given to the two other judges, and they review it and decide if they go along with it or they disagree. If they disagree with the case at that point, what they'll do is they can file a dissent, and a lot of times what happens is they may come back to the judge that wrote the case saying, I don't agree with this, it's a little hard here, it's a little bit too strong on the edges here, can you change that? And a lot of times the decision will be softened or changed to be more tolerable to a judge that may disagree with it, and they may go along with it at that time. Other times they say, well, you didn't change it enough, and they have to dissent. It's sort of there's different policies and procedures how judges view dissenting or how they want to change things. It's sort of like in that procedure. Judge Sullivan, do you have anything you wish to?
Well, as you can see, this is not like TV. We're not one judge that sits and you didn't have witnesses and a jury. Our job is very different because we're a court of error. We look at the trial court and the decisions that were made by in this case, there was a commission and there was a trial court, whether there was error in any parts of those decisions. And we are not the captain of the ship anymore. Judge Gertner and I used to be circuit judges, and we were the sole deciders. Now we sit in panels of 3. And so, as Judge Gertner indicated, 2 of us at least have to agree on a decision. And we get our cases, by actually they come on a rolling basis, so they're assigned randomly, and they go into our panels, and then our administrative assistants actually pull out slips that will indicate which of us will be the writer. So it's all done randomly. Judge Gertner is presently our chief judge, and he actually assigned the panels at the beginning of the year, and that's where his power begins. Everybody will wash his car, do whatever they need to do to get a good panel, and then he loses his power, and then then he just has to do all the administrative work for the rest of the year. But no, he is our chief and is doing a great job. So that's kind of how we operate, which is a little different than the trial court.
I haven't had any cars cleaned, unfortunately.
So, do you have any questions about, where we've come from, how we got here, about the process? Is anybody interested in, how you become a judge? I see a hand.
I hate to say it, would you mind? I'm so used to talking in big rooms. And if you would stand up, you project your voice a little bit better. And I'm trying to see, I just couldn't hear. Go ahead.
Time limit on their arguments.
Yes, what happens is on these arguments, they have 15 minutes. They can take up to 15 minutes on each side. And then the person who's the appellant who lost down below, they can get 3 minutes on rebuttal. Sometimes people have a very short case. They'll say, I just need 7 or 8 minutes. But a lot of times they take all 15, and there's a type of cases called accelerated cases, and they get 10 minutes aside at most, and then 2 minutes on rebuttal. Judge Clayton, do you have anything you wish to?
Who's ready to go to law school now? Raise your hand. Got one?
We got one.
Got one. Got any questions? If you're going to go to law school, you're going to have to stand up and just belt it out so we can all hear it.
So your guys' decision is final on the cases?
Well, go ahead.
Well, what happens is that you have a lower court that makes a decision, case gets appealed to us, we get, if you lose your case, you have a right of an appeal, and most of those cases come to us. The cases we don't get are like to the death penalty cases that go to the Supreme Court. Usually, once we make a decision there, they are final, and if we reverse, it goes back and the case kind of starts over. If we affirm it, then it's done. You do have a chance to go to the Supreme Court, but they take very few cases. There's one other level, but they get to choose what cases they get, other than death penalty cases or taxation or constitutionality cases.
And it's, and I don't want to be 100% certain on my statistics, but I think I'm pretty accurate that 97% of cases that, whether it's appealed from municipal court, whether it's appealed from associate circuit court, or whether it's appealed from the circuit court, they all come up to the state court of appeals here. Those are all state courts. We're the final court of say as an appellate court for 97% of those cases. So 97% of those cases aren't going to be appealed to the state Supreme Court. They're not going to be able to be litigated over in federal court. So realistically, good or bad for the litigants, if they lose here, there's very little wiggle room they have. Generally, 97% of the time, it's done. And so, from that perspective, it's the state Supreme Court. We handled 40 to 45% of all the appeals from. We have a Western District, Southern District Court of Appeals, and the Eastern District Court of Appeals. We go from the border of Iowa, Clark County, and I guess Scotland County up there, all the way down to Cape Girardeau County, and we go out east of Columbia, Missouri. So we handle, I think, about 45% of all appeals in the state here. And I think we handled about, our court administrator, we handled over 1,500 cases, I think, don't we? 50% of the appeals. 50% of the appeals, we handle over 1,500 cases. So I looked at it once, and less than 3% of the cases get transferred up to the Supreme Court for their review. So if you're looking at 3%, you're talking only, 45 cases out of our district. So the Supreme Court is really a policy. They're taking very small number of cases. It's like a pyramid. The trial court has tons of cases. If we had as many cases as the trial court, we only have 1,500 cases for all those jurisdictions. One trial court in Jefferson County could handle 1,500 cases in a year. So it's really a pyramid. It goes down to us, and then it goes to the Supreme Court. And then, ultimately, you can appeal to the U.S. Supreme Court, and that's the chance of that is 0.001.
There is a great example of a case that was just accepted by the United States Supreme Court that, this is exciting stuff for us, so you got to understand.
Rubber hitting the road.
There was a case down in Cape Girardeau County where a person was arrested for drunk driving. He refused to give a breath test or a blood test, and the arresting officer went ahead and took a blood draw without his consent. And the trial court in Cape Girardeau said that that was a violation of the Fourth Amendment of the Constitution, an unlawful search and seizure. It was appealed to our court, and our court, although I wasn't on it, I don't know if you all were on it, reversed it and said that you could take a blood draw without a warrant. And then it was appealed to our Missouri Supreme Court. They reversed it the other way and said you cannot do it. And now the United States Supreme Court has taken that case. It rarely happens, but they will make a decision based on a Missouri case whether you can do a blood draw on a DWI defendant without a warrant signed by a judge.
Just to clarify, the police officers aren't out there drawing blood. It was done at the hospital by a nurse, but he had it at his direction. So don't worry, they're not going to be out there taking blood out on the side of the road. But
well, I don't know if you may want to worry about it.
What I'm going to ask is, do any of the lawyers that gave their arguments today, do they wish to say anything to the audience or anything like that? You're welcome to. You don't feel obligated to do it.
any questions for the lawyers?
Well, yes.
state finalist for the state of Missouri. And it was, for anyone who wants to be a trial lawyer as part of their legal career, to move toward programs, even for the high school students around the state of Missouri. A lot of the attorneys, some of us here, have participated as judges or jurors on the high school level for the moot court competitions. And it's very interesting and very beneficial.
If you're thinking about going to law school or you have the opportunity for moot court, one thing it will train you to do that you will find out the first time you're before a panel of the Court of Appeals is you can prepare all you want and have all of your arguments set out, but these judges are going to let you know pretty early on with their questions what they believe is significant and important and what you should be addressing.
I really appreciate everybody coming down to Jefferson College and being down to Jefferson County today. We, on behalf of Judges Sullivan, Judges Clayton, and myself, we really do appreciate it, and we like getting out, and we like to, there's a lot of cases that come from Jefferson County, and we're happy to be down here. We look forward to coming again. So thank you very much, and appreciate your time.